All right, good morning. We're going to get started. Whatever the way if someone is a clapper or something can get us started. Good morning, everybody. Thank you so much for being here. I am Jennifer Weiss-Wolf. I am the Executive Director of the Birnbaum Women's Leadership Center, and we're so happy to have you here at our 2025 Deckert Symposium, The Collateral Damage of Jobs on Women's Health Beyond Abortion Care. I want to start off actually by thanking Deckert, and I know we have some folks from the firm here today. We are so grateful for your support for this symposium. Thank you. This is an event we put on once a year in the spring, and we try to be creative and thoughtful about what are the topics of the moment, the discussions to have. And I will say that's really hard to do at this moment. I was thinking I could riff on a morning headline, but there were too many to choose from. But and I'll also say that when we created the idea and developed the program for this, we knew it was coming. We knew we were actually going to be reflecting on the 2022 Dobbs decision. But I actually can't say that I knew the exact environment we'd be having this discussion. And I want to put that out to everybody as both a challenge, to be clear and to be sure, but also an opportunity. I think there are new and different ways we're going to be thinking about how reproductive health, how women's health is impacted by so much that's happening across this administration and across the courts. And I hope that being here and actually threading the needle on some of these issues that perhaps get less of the public's attention and less necessarily elevated in the public discourse, including IVF, including menopause, including maternal care, including maternal cancer care, is an opportunity for folks here to think collaboratively, to think creatively about what potential solutions are. I think one of the things that makes me really proud and excited about this symposium, while we are based here at the law school, we are very advocacy and action focused. We are very practice focused. Our symposia are as we love legal scholars, but are not just filled with legal scholars. We have practicing physicians, we have journalists, we have advocates, and we have activists here to talk with you from the stage and amongst you in the audience, to share in what I hope are really generative conversations throughout the day. I want to do a little bit of brief housekeeping before we get started. There should be Wi-Fi codes on your table. There's food and drink outside. There's CLE being offered today for attorneys. You do need to sign in and sign out to receive that, so please don't forget to do that. We will be serving lunch in the afternoon, and we'll be treated to a fireside chat with Professor Melissa Murray, who is the faculty director of the Birnbaum Women's Leadership Center, together with Alexis McGill-Johnson, the CEO of Planned Parenthood Federation. And if you need any assistance throughout the day, our amazing, extraordinary team is here to help you. Claire Whitman, Sherry Arnold, and especially Shirley Dang, who is the creative force who makes our events happen. So thank you to them in advance, and I know they'll be here to help you throughout the day. And thank you as well to all of the amazing support we have here at the law school, from IT to the folks who are helping us stay fed, safe, and seated all day. So thank you to everybody here at the law school. With that, I'm going to turn the floor over to my dear friend and colleague, Professor Kim Mutcherson, who is the Beck Chair of Temple Law School, Professor of Law and former co-dean of Rutgers Law, Camden, and the fellow in residence here at the BWLC, who we love dearly. So she will introduce the first panel of the morning, who are going to be focusing on IVF and for assisted fertility, and I leave it to you to take it away. Thank you.
Awesome. Thank you so much, Jen. So it is really wonderful to be here this morning. I feel like BWLC is a family for me now, so it's really great to be back here again. So I am very lucky that I get to talk to three really terrific people this morning. Directly to my left is Professor Michelle Goodwin, who is the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy, and also the co-faculty director of the O'Neill Institute for National and Global Health Law at Georgetown's Law School. So welcome, Michelle. Next to her is Mark Joseph Stern, who is a senior writer at Slate. And then next to him is Karen Thompson, who is the director of litigation at Pregnancy Justice. So I want to just sort of frame the conversation that we're about to have really quickly. This is a panel that is focused on IVF and the fertility industry. And as we're having this discussion, it really is going to be a conversation. We're going to be clear that the legal and political attention to assisted reproduction, which includes but is not solely about IVF, is a gateway to a really broad range of conversations, including discussions of embryonic and fetal personhood. I was at a meeting recently where we were told that that language doesn't resonate with people. We should start saying ascribing legal rights to fetuses and embryos, which is really unwieldy. So I'm going to keep saying personhood, but you know what I mean. Bodily autonomy for buyers, sellers, and for patients, the question of choosing the children we will have, selecting for or against disability and sex, and of course the questions of eugenics that always swirl around using assisted reproduction, restrictions on family formation, especially for people who are not white, who are not straight, and who are unmarried, the regulation of the medical profession, patients' rights, and pregnancy criminalization. So anticipate a very wide-ranging conversation that we're going to have here this morning, both about law and politics, and we will definitely leave time at the end so that we can have conversation with the audience as well. So I want to start with my friend Michelle Goodwin over here, and Michelle and I have been talking about issues related to assisted reproduction and the relationship between assisted reproduction and abortion for a couple decades now. So when people are surprised by things, we're like, we've been talking about this for 20 plus years, right? So this was all very inevitable from our perspective. But one of the quotes that I often use when I give talks, Michelle, is a quote from our friend, Dorothy Roberts. Yes. And what she said is that the thing about reproduction is that more than anything else, it tells you how a society values people, which I think is a really profound statement in a whole host of different ways. And so where I want you to sort of start us off is giving us kind of a foundation, right? So you have thought very deeply about the ways that reproduction and reproductive oppression has functioned in this country along a whole host of different lines. And I think that that's an important part of understanding how we are getting to where we are now.
Well, thank you so much for that, Kim, and thank you also to Jen and Melissa and the community of people who helped to bring us together in the Deckert Law Firm. And you're so right, because it's been decades that we've been talking together, working together, writing together, and almost annual roundtable called the Baby Markets Roundtable, which significantly addresses many of these issues. So look, we can't divorce the times that we're in now, whether we're looking at them politically in terms of where we are, or matters of reproduction in these times, from origin stories, right? And those origin stories say so much. Culture is something that's very difficult to change. You can change laws all the time. You can make amendments to a constitution. Can you root out, and how do you root out certain diseases in a society is really hard. Can you even ascribe the proper language to it? So if we're to be honest, right, if we're honest, we're in a space where there has been colonialism, if we're honest. If we're honest, then we would honestly talk about a trail of tears, where there was no care or consideration whatsoever for the women, the pregnant women, the children on that trail, to march them out of the spaces that they were in to other places where then again, there was absolutely no care. And if we're honest, we could tell a story where right aside, or maybe before Thomas Jefferson, we'd talk about Sally Hemings. And we'd perhaps talk about Thomas Jefferson differently if we actually talked about Sally Hemings. We would perhaps describe Thomas Jefferson in a more nuanced fashion in the ways in which he left a record behind for us. Like, we don't have to imagine, we only have to look at what Thomas Jefferson wrote, right? So when Thomas Jefferson writes to John Wells Epps, who was another politician who happened to be related to him, and he was giving advice, right? Here's my advice about what you need to do to make money and to have your plantations. He said, well, for me personally, I prefer to stock mine with girls and women because they turn a profit every year or two. Now, Thomas Jefferson is not talking about, oh, these black girls, they're just so adept at picking cotton. They are really good at tobacco. No, Thomas Jefferson is talking about having a plantation that is like a brothel. They're turning profits every year or two. Except what I want for them to do is to reproduce. And he's kept copious records, copious receipts. Here's how much I can sell the offspring for. And if we were to talk about a story about Sally Hemings, which then again, these origin stories really help us, right? Then we tell the story about a 13-year-old who actually happens to be his wife's half-sister, right? Martha's dead. He's politically going over to France, and he's sending for the 13-year-old who leaves at 15 pregnant with his child. And then there are about 5 other ones. And then we think about the complications of that, right? Because in her story is the complication of her brother, who's also there, who's a chef, brought there because Thomas Jefferson liked to eat and liked to do it well, right? And is having the chef, her brother, trained in France. And the brother's saying, Sally, let's stay in Paris where we can both be free. And Sally is thinking about, we've got relatives back in Virginia, right? Like if Sally is given any kind of thought, if women today are given any thought, if the idea of women who were captured, kidnapped, enslaved, right? Like we talk about slavery like, oh, it's slavery, but we don't think about it's kidnap. It's sex trafficking, it's labor trafficking, and it's being done to people who had things to do on the day that they're captured, right? But this is the way in which we give no dignity to the lives of Black women. None. People do not think like, well, what was happening to her on the day that she got kidnapped and labor trafficked and sex trafficked? Was she just sitting there waiting for Europeans and Americans just come over and just snatch her, right? Like nothing else to do. Like she had no family. Like she had no cousins. Like she had nothing to do on that day. And significantly, I think that that is a part of an origin story for us that we don't tell. And so with that disregard, it continues today, and I guess I'll end with this because there's so much that could be said on that. But I wonder, and perhaps this is a way of getting us to think about these issues more, sort of a nuanced way, is what story does a mother tell her child the night before the slave auction when they're going to be separated? And the fact that we don't think about that question, the fact that we don't even bother to give any attention to what story does a person have to convey in a society that says that she and her child are no higher status than a goat, a pig, a mule, or anything else in law. That's what law said. This is who you are. And she has to think about something in terms of an active personhood of a living child to give that child something after being separated away, that you are a person, that you are somebody, that you actually have worth, value, meaning no matter what this society in law, state law, federal law, and people who are around you will tell you such that you could survive this.
All right.
Can I just point out that I think much of what Michelle just said would be illegal for a professor to say at a university in Florida or Texas or many other states that have enacted these censorship laws and restrictions on just frank discussions about race and gender and this history. And I think that the existence of those laws just demonstrates the power of these stories, that that there are many people who do not want us to share or think about them. So I'm very grateful for that, Michelle.
Absolutely. Yeah, there's something so painful about that history, and so painful about the fact that people don't want to talk about it, right? And that we lose that sort of understanding, I always say, of what this country is capable of, right? So Karen, I wanna hop over to you. Your work is very much grounded in pregnancy criminalization, and maybe you could start off by telling us what you mean. It was on when I sat down, so maybe yours is on too.
It is.
Okay.
Yes.
One, what do we mean by pregnancy criminalization, and then thinking about how these conversations about ascribing legal rights to fetuses and embryos, or in other words, deciding that a fetus or an embryo is a person, how does that play into these questions of criminalizing pregnant people?
Absolutely. So pregnancy criminalization is simple, and I want to honor Lynn Paltrow, the founder of Pregnancy Justice, who's here with us today, who started litigating these cases and bringing these questions to the fore way before Dobbs, way before people were maybe making these connections. But pregnancy criminalization is where pregnancy makes something that would have been legal in any other context illegal. It's that simple. So people who are being criminalized for their pregnancies, for not doing them right, or for their pregnancy losses, so their miscarriages or their stillbirths, or for abortion. We recently released a report that is tracking pregnancy criminalization cases in the 2 years post-Dobbs, but Lynn also had another report that basically tracked pregnancy criminalization from 1974 to the day before Dobbs was issued. And the strange thing is what we know is that the numbers do not show that people are getting criminalized for abortions in the same way that they are getting criminalized for everything else, right? So to tag off of Michelle's words, what is happening in pregnancy criminalization is that the person is not actually the person who's pregnant, but the fetus. So even though fetal personhood might sound pithier, I think it's important for us to actually say what is going on and to name what is going on. And that is that people are saying that an embryo or a fetus, as we saw in Alabama in the LePage decision, deserve to have the same rights as everybody in this room. And Dr. Mutcherson named this, but she said we need to have a jurisprudence of pregnancy, not a jurisprudence of abortion. And what that means is if you have a jurisprudence of pregnancy, then there is only a unitary pregnant person. There is only a person who is pregnant, and all of the rights are ascribed to that person and to nothing else, because you cannot have fetal rights without conflicting with the rights of the person who's carrying the pregnancy. There's no in between. There is no middle ground. There are then two people with interests. And guess what? In our society, because all of the reasons that Michelle just named, because of misogyny, the rights of the pregnant person are going to fall to the fetus. Because when I was a deep academic over at Tisch in the Performance Studies program, I was taught by an amazing woman named Peggy Phelan, and she had this fabulous piece called Unmarked, and in it she talked about how Operation Rescue at the time was basically projecting themselves into the fetus, right? So it was always like, here is a potential man that you are taking from the world, and so as a result, I need to control that person, and I don't want to get into the Lacanian psychoanalysis of it all, because that serves no one. But what that looks like in real life is that we have to fight people who are getting charged with murder, and the mens rea for that is that they had the audacity to look up abortion care, and they had the audacity to not get prenatal care, and they had the audacity to not tell anyone that they were pregnant. That was enough for the state to say that was a mens rea to murder a baby. What does it look like? It means that if you take drugs, right, if you have a substance use disorder, if you have a medical marijuana license and you smoke in Oklahoma, when you're pregnant, a prosecutor can then charge you with child abuse. And the argument by the prosecutor there is that the fetus should have had a medical marijuana card, right? So the things that seem illogical are actually becoming more and more day to day, and all of it is about giving a way for the state to survey people's bodies from the minute they become pregnant. And another thing I just want to tie into the fetal personhood question is the question of the viability line, because look, Dobbs was flawed. You know, like obviously the rights that it protected are important ones, but when you say that a viability line is the way to make the right decision, what you're saying is that you're still saying fetal personhood is real. You're just saying that fetal personhood becomes more palatable the farther you're along in your pregnancy. But the thing is, when you push things farther, you can also push them earlier, which means that if you have a 2-hour-old fertilized egg, that is the moment that your body can become a crime scene. And all of that is dangerous, and we know it because we see the cases, and they're not getting smaller. They're in fact increasing rapidly. So given that we're having less ways to push back, given that we're giving more rights to something that actually is not entitled to them, and erasing the rights of the person who is entitled to them, we're in a very dangerous and scary moment right now, which everybody knows. I'm not saying anything new. But I think we have to pull our focus a little bit from the question of abortion to kind of these engendering primal scenes of criminalization.
Thank you. So, Karen, you mentioned the LePage case from Alabama, the infamous LePage case from Alabama. And Mark, I want to ask you to talk about that case a little bit. And that's one of those things where, I got all these calls from press after it happened, like, how could this happen? And I was like, where have you been, right? But I want to read a passage from the concurring opinion in LePage, and then I want you to talk about how we should feel about where we are going, not just in Alabama, but in lots of other parts of the country. So LePage was the case in Alabama where the Supreme Court decided that frozen embryos were children for purposes of the state's wrongful death statute. So this was a concurring opinion that was written by the Chief Justice of the Alabama Supreme Court, agreeing with the idea that an embryo is in fact a child for these purposes. And so he wrote, the people of Alabama have declared the public policy of the state to be that unborn human life is sacred. We believe that each human being from the moment of conception is made in the image of God, created by him to reflect his likeness. It is as if the people of Alabama took what was spoken of the prophet Jeremiah and applied it to every unborn person in the state. Before I formed you in the womb, I knew you. Before you were born, I sanctified you. That's from Jeremiah. In case, like me, you don't read the Bible. All three branches of government are subject to a constitutional mandate to treat each unborn human life with reverence, carving out an exception for the people in this case, small as they were. Remember, we were talking about frozen embryos. Would be unacceptable to the people of the state who have required us to treat every human being in accordance with the fear of a holy God who made them in his image. End quote. This is a court opinion written in 2024. Take it away, Mark.
Wow. There is a lot I could say. Much of it I don't think I'm allowed to in this setting. I do just want to point out that as the parent of a child conceived through IVF, reading that passage, never have I felt more that my own rights to religious freedom were being violated. I mean, what the Chief Justice wrote there is just so obviously a fundamentally theocratic, dogmatic, evangelical view of human life that I do not believe in, that I fundamentally reject. And the kind of scolding and the judgment that is imbued in that passage toward people who do use IVF or even believe that IVF is a good thing that others should be allowed to use feels to me like an egregious violation of the Establishment Clause, if the Establishment Clause still exists at this Supreme Court at this juncture.
For some people.
Yes, well, I mean, I mean to say that decision sort of raises the question of, can a legal opinion violate the Establishment Clause? And I think if so, then that one surely does. We've talked about this case a little bit. I think the background is notable. What happened here is that there was an IVF clinic in Alabama that was, I think, by all accounts, arguably negligent. They did not sufficiently protect the frozen embryos, and someone from another part of this medical facility damaged the frozen embryos, which is tragic and, if proved, negligent, and the clinic could have been subject to all kinds of damages. But the parents, the intended parents of the embryos, they did not ask for regular damages. They sued under Alabama's wrongful death statute, arguing that the clinic was liable for the destruction of human life, for the destruction of a child's human life, and that the clinic was therefore on the hook for massive punitive damages that apply when an entity is civilly liable for allowing a child in its care to die, like a daycare allowing a child to die through negligence. That was the analogy. And it was a backdoor to embryonic personhood. I'm not sure if the actual plaintiffs understood that. They did not do presser on this case, but their lawyers sure as hell did. And what happened was when a group of anti-abortion lawyers discovered the existence of this case, they swarmed it. and pressed it as far as they could until they got a victory in Alabama. And the Alabama Supreme Court, by a 7-2 vote, it's an all-Republican court, agreed that the, I believe, 1872 wrongful death law applied to what the court termed extrauterine children. Those were children in cryo nurseries who were, in fact, fertilized eggs. I know that scientists tell us that at that stage they aren't even technically embryos, but I'll use that for shorthand. So the court allowed for these punitive damages to move forward and had all kinds of horrific language about how, there's another line in that opinion about how a vengeful God would smite Alabama if it didn't protect these little people. I think it was tricky to cover as a journalist because we want to hold fertility clinics to high standards. We want to ensure that embryos are well taken care of. But we also have to recognize that no clinic can operate when it is subject to ruinous damages for the death of an actual child when regrettably something goes wrong. No clinic can operate under the circumstances that the Alabama Supreme Court created by declaring that all of these embryos were children. And there was also language in the opinion that suggested that this was maybe the start, not the end, of the Alabama Supreme Court's declaration of embryonic personhood. The majority said, well, there are all these questions that we aren't answering today, like, could the clinic be liable for homicide if it destroys an embryo? Are embryos actual children under various other statutes that have criminal penalties attached, which could mean that it would be illegal for a clinic to destroy an embryo, which is, common practice for unused embryos and would mean that IVF simply couldn't exist in Alabama. Even under the terms of the allegedly narrow decision, IVF couldn't proceed in Alabama because, again, a clinic cannot operate when it is subject to punitive damages for the death of an extrauterine child. And so there were women who were in the middle of treatment for IVF, who were days away from an embryo transfer, who had spent months getting the shots and doing all of the preparation, who had spent thousands of dollars because Alabama sure does not require health insurance coverage for IVF and fertility treatments like that. They had spent thousands of dollars out of pocket for all of this medication, and they were told on a phone call, sorry, we're shutting down our clinic. We can't operate like this. Your appointment has been canceled, and we have no idea when we will resume treatment, which was absolutely devastating to many families, including many Christian white women who came out of the woodwork in response to this decision, who got what I would say was an inordinate amount of media attention compared to all of the other people who were affected by this, who had the money for this treatment and the means to get it, and who went out and to the state capitol and to the state Supreme Court and to protest and to the media and said, wait a minute, this affects us. We weren't protesting when Dobbs came down. We weren't protesting when reproductive rights were taken away from other people. But now we're the ones getting the call saying that we are not allowed to we can't get IVF because our clinics are essentially not allowed to operate as they must. And remarkably, the overwhelmingly Republican state legislature responded to those women. The same state legislature that had doggedly pursued abortion restrictions for years, that has imposed a near total ban on abortion, that has criminalized pregnancy in many different ways, that has put women in jail for allegedly using substances while pregnant. That legislature passed with overwhelming margins a law that shielded IVF clinics from essentially all liability, that arguably went too far, in fact. But there was just sort of mass panic here, and of course a lot of Republicans on the national level got involved, and there was sort of a memo that went out that this was too far. But then I think there's a very interesting question at the heart of all of this. Why exactly did this go too far? Because many, many states have enacted 0-week abortion bans. Many, many states have said that when the egg is fertilized inside of a person, that from that moment, that is a legal person and they cannot get an abortion, except in very extreme circumstances that are difficult, if not impossible, to prove. And so if you take the logic of these 0-week abortion bans seriously, then in fact, IVF should be illegal. The destruction of embryos, which is, again, a regular part of IVF and sort of inherent to how it is practiced. You have to allow clinics to destroy unused embryos, otherwise IVF cannot happen. That is akin to a pregnancy termination and should be illegal. But lawmakers in Alabama and elsewhere could not fathom or could not swallow the logical sort of consequences of that theory, and so they pulled back and retreated. And I don't have a sort of grand unifying theme to close all of this together, this episode, but I do think it shows that the forces on specifically on the right that are combating reproductive freedom. First of all, there's a divide between those who are such true believers that they would force even Christian, Republican, blonde, white women into foregoing fertility care, and those who can't quite swallow that and think that there are some women who should be exempt from those laws because surely they deserve it. And in fact, the governor of Alabama had this quote where she said, some families deserve to use IVF. We have to protect those families. I don't think it was hard to guess which family she was envisioning. But also that there are a lot of people on the other side within that movement who say, yeah, we do want to pursue this to its logical extreme. We absolutely want to prohibit IVF and the destruction of embryos and make it impossible for couples who are infertile for whatever reason to conceive with assisted reproductive technology. And they have a 7-2 majority on the Alabama Supreme Court. They had some votes in the Alabama state legislature. They are very powerful, influential, and well-funded. They have lawyers who are looking for the next test case on the subject, who are not cowed by the public backlash to the Alabama decision. This fight is certainly not over. And so for all of the people in the United States who have tuned out of the abortion debate, who think, this doesn't affect me, this isn't going to happen to me, this isn't my fight or the hill that I'll die on, I think there are a number of them who are eventually going to discover that this is coming for them and their rights, that this is not going to end with abortion, as you were saying, that this is much broader than just abortion. This is about the full spectrum of reproductive health care and cutting it off in the name of protecting extrauterine children, and anyone who thinks that it'll stop with a 6-week ban or a 0-week ban or just a little criminalization here and there of pregnant women, they are deluding themselves and they are in for a very rude wake-up.
Let me pay attention to time because I'm going to get very engaged in this and then forget. So Michelle, I want to go back to you because, again, I think that there's a historical perspective here that's useful. And part of that historical perspective, and this is something that we've talked a lot about when we were doing baby markets and all those good things, is that assisted reproduction has never been regulated in the same way that abortion has been regulated in this country, in ways that are shocking, right? So even practices like selective reduction, right? So let's say you get 2 pregnant, right? You get pregnant with 4, and really it's dangerous to carry 4, and your reproductive endocrinologist says, I can fix that for you, right? I can make it twins instead of quads. Has never been called an abortion, has never been regulated the way that abortion has been regulated, right? Nobody's waiting 24 or 48 hours after informed consent to do a selective reduction, right? None of those rules are being applied to that. So there's always been this sort of carve out for assisted reproduction. And I think it's really important to talk about, one, that it existed and still exists, why it exists, and the implications of carving that out.
Well, I appreciate that, and a thread that I'd like to get to from both what Karen spoke to and also Mark. But you're absolutely right, and we've been talking about this from the start, which is that no federal regulations or rules with regard to assisted reproductive technology, save for the success rates law, which basically required that clinics, and this was good, report out how many cycles are taking place, what are the ages of the individuals who are coming in who are looking to utilize these technologies, are there pregnancies resulting, and then there are the gaps, and we often talk about the gaps with the nomenclature, right? One gap, success rates law. Well, what is success? What does success count for? There are the sort of gaps in understanding, well, it can be like a lottery. 64% failure rate when you're going through these cycles. What does it mean when there's the hyperstimulation of the ovaries as a health-related matter? The issues that you've raised with regard to selective reduction, right? A whole different language assigned within these spaces. The failure to be honest about what's taking place when a person is willing to provide sperm in this space and be paid for it, right? The language that's a donation. Is it really a donation? Right? Like, is that a donation? He's getting paid for this, right? But the failure in that way, right? So we're just going to gloss and call that donation. Or in fact, when they're well-meaning, happy to have people grow a family, but realizes she can get paid $50,000 for providing her ova, and that's a donation, right? And all of these things painted and glossed within white space. Right? So like within white space, these are the ways in which we can talk about these things. And the failure to engage with what do these issues mean once they travel internationally, such as surrogacy, gestational surrogacy, the utilization of uteri in Nepal, in parts of India, in China, in parts of Central and South America, right? People who are agreeing to be gestational surrogates that Americans know that she can't read. She can't read in her own language. She's signing these documents with her thumbprint or with an X. And part of this contract allows you to implant as many embryos as you desire in her uterus, but you are making clear that you're only going to take one home. And so if she, in fact, experiences multiples, right? There's sort of multiple fetuses that grow within the uterus, that she can be subjected to the selective reduction without having any kind of say in it. And then to speak honestly about what are the trade-offs within those particular spaces, because the truth of it is, for any of you who've ever been to Bihar in India, and I've been there a number of times, but Bihar is a kind of place where Americans go for kidneys, go to rent, all those things. And usually the women from Bihar, where it is the concentrated space in India where there's very high rates of underage marriage, right? I've interviewed families and girls. I interviewed one girl who was 15 years old, about to get married to her second husband because the first one died, and she was back at home and the family was ready for the next husband, right? And so for girls who are growing up in those spaces and for women growing up in those spaces, it's often like, okay, what do you want? If you want to learn how to read, you want sanitation, and you want something good for the next, 9 months, we can take you to Delhi. And that looks better than being in Bihar, right? So all of those kind of nuances are not really dealt with, and they're not really dealt with because there's a sort of privilege that goes along with race and class within spaces of reproduction. And that actually brings me to something, again, in terms of thinking about how we stitch together, because there is this habit that's formed in our country of thinking about what is left behind, and that was involving people who were poor and vulnerable, but especially with race, has nothing to do with today. And it is a big problem in our country. So as I was listening to you, Karen, and I was listening to you, Mark, all right, so we're talking about Alabama, right? And this relates to us this week, right? Because this is an anniversary of Bloody Sunday. Where was that? Alabama. The 16th Street Baptist Church, where 4 black girls get to be blown up. And nobody, we can't, you've got recordings of who did it, but somehow we can't convict this man until literally decades and decades later, because hear no evil, see, little black girls can be blown up on a Sunday in Alabama, right? The Supreme Court in Alabama that you spoke to was the Supreme Court that, as we know, right, like decades before, it decided under Roy Moore that there was no distinction that the state found between, in a criminalization case, right? No distinction between a child and a fetus, and no distinction between a viable fetus and a non-viable fetus. Now, Roy Moore, how does Roy Moore not, sort of fail in his bid to go to the Senate? It's because black women were like, we're not sending you to the Senate. Where white women are being interviewed and are saying, huh? And Roy Moore is the person that local prosecutors have said, you are banned from going to the malls because we have spotted your pedophilia not against black girls, but little white girls. But it's black women saying, no, Roy Moore, we're going to keep you from going to the Senate. There is a Venn diagram that we can draw from these spaces. What are the earliest states here that began doing, right? Like, we're going to put these trigger bans in place so that when, Roe falls, we'll be ready to ban abortion altogether. It's the former Confederacy, right? It's Alabama. It's Mississippi. What is the state that actually delivers Dobbs? It's Mississippi. Right? Our failure to understand these connections where there is a lack of care and concern about the political life, the social life, and the care, historically for black women, but that also includes, white women too. I think it's worth noting, and I'll end on these 2 points. It's worth noting that in the district court opinion that staved off Mississippi's abortion ban, it was such a brilliant district court opinion. Judge Carlton Reeves, brilliant, a black man from the South, who said, Mississippi, I spot you. I spot you, Mississippi. When you say that your abortion ban is about protecting the health and safety of women, Mississippi, I spot your gaslighting, the term that he uses in the case. He says, Mississippi, you're the state where women couldn't serve on juries. You're the state where women couldn't open up bank accounts in their own names. You're the state that denied women the ability to be able to have credit cards in their own name, right, if they were married. You're the state of the Mississippi appendectomy, which was no appendectomy at all, but the coercive sterilization of black women by incredibly high percentages. Mississippi, I spot you. You have actually shown no care historically for the political concerns, the legal concerns, the health concerns of women, Mississippi, and we know how people will be harmed. And I think that legacy, we have to understand where all of this is coming from intergenerationally that has not been stopped. Our failure to stitch those things together, and let me just say this. In 1865, the 13th Amendment was ratified. It banned slavery and involuntary servitude in our country. When did Mississippi ratify it? 2013. So if we are confused at all about, what are the histories, you got to practice it like a muscle. Like a muscle is, I see you, I respect you, I think you matter, I think your rights matter. And if it's not been practiced, literally for centuries, what are you expecting? Truly.
So Karen, I want to, and I should just let folks know, I'm going to ask Karen a question, and then I'm going to ask Mark a question, and then I'm going to open it up for questions. So be thinking about your very astute questions that you want to ask. So Karen, I want to stick with Alabama, because if you can talk shit about Alabama, just do it, right? Because one of the things that Alabama has is a sanctity of life provision in its state constitution, and they are not alone in having that kind of provision. And when those provisions first started sort of proliferating, courts were basically like, it's just sort of a statement of thought, right? It doesn't really have an impact. Let's talk about that, right? Yeah. So when we have these states that have these particular provisions, some of which have been around for quite some time, how do those get played out, right? It's not just a statement of principle. It's more than that, isn't it?
It's definitely more than that. And I think that the way that we see it is, for example, in the case of one of our clients who she was pregnant, had a stillbirth, and was prosecuted under the guise that her drug use caused the stillbirth, right? But even at the trial, the medical examiner was like, well, there's a pretty clear evidence here of intense infection, right? And I can't actually call the cause of death. And the judge is like, well, I don't know if I can even go forward if you can't say that the cause of death wasn't natural. And her attorney was like, well, that might require a little digging into, but no one actually did anything, and she got sentenced to 20 years, right? So to go back to the fetal personhood question, the sanctity of life does not belong to the pregnant person. And there's no actual scientific evidence that is being brought in a prosecution to show that this theory of harm to the in utero fetus is real. So like the bar is so low that ants are like pole vaulting over it. And then there's no like, there's no burden for the prosecutor. The only burden is the exposure. And so it's like the legal standards are so pathetic. The lawyering is not great. And no one cares because this is a bad woman who was going to be a bad mother. And the only thing that matters is that she harmed the life of the child, right? So it's a very, it's a very slippery slope because anything is justified. And that's what I mean by the pregnancy being a crime scene. Because the other very real American thing here is that a carceral response is the only response. And so even though there's a healthcare question that was, in that case in particular was driving the issue, the only response to it was that she should be imprisoned. So the other, we have a federal case right now going on where someone gave birth 14 hours on the floor of a jail cell and got no help. So do you really care? Is there an interest of the child here? Is there a sanctity of life here if you are willing to literally watch someone scream and writhe in pain for 14 hours and not provide her assistance for the delivery or to actually ease her pain? And I feel like I keep saying this over and over again, and it's like the weirdest thing to quote Teddy Roosevelt, but I am, because I think it has to inform, if only a question of interest convergence, right? And I'm completely with Derek Bell, because I think people's eyes shudder when we start talking, not shudder, but shutter, when we talk about race, right? Because I don't know, people don't want to hear it anymore. It doesn't feel salient to the questions of abortion or reproductive rights. But I'm here, like, you might not care about Black people, you might not care about Black pregnant people, but there is no untying what is happening right now. So when Teddy Roosevelt in 1903 says the battle of the races is a battle of the cradle, and in that battle we will have breeders and we will have warriors, he wasn't talking about Black women. The breeders are the white women in the room, right? And the laws that we are seeing now are kind of overlapping with what we're also seeing out of this administration around their racial panic and their racial demographic panic, and the fact that they want to force white women to have more white babies. So we can either understand what the roots of that are, what's actually going on here, and how that's informing the fact that there are 7 bills making their way through state legislatures, making abortion, because of fetal personhood principles, murder, literally, redefining abortion as murder so that abortion then becomes a homicide. That's all of us on deck.
I think one of the things that's really, I just want to stress about those bills is for a very long time, it was sort of understood in anti-choice circles that you didn't go after women who were having abortions, right? You went after the doctors who performed them because women were being, enticed and forced into having abortions, because what woman would have an abortion? That is changing, and that's going to change really rapidly, and the landscape's going to look really different. So Shirley held up a sign that said Q&A, but I didn't see it. So I'm going to ask Mark one last question, really, really quickly, Mark.
Pressure's on.
Which is about the IVF executive order. Because, of course, as now President Trump told us on the campaign trail, he is the father of IVF, which is just terrifying to even think about. But we now have this EO that came out that basically says, it really doesn't say much of anything, right? It basically says we have, 90 days to figure out how we can make IVF more accessible, cheaper, all of these good things. Tell me how cynical we should be about that.
Well, first, I love that I'm the one who gets to keep talking about IVF, because I think I'm the only male panelist in this entire event, which is a huge honor, and I love it. It brings me back to my art history classes in college. It's a very comfortable place for me to be. This order is bullshit. It does nothing. it is in fact related to the Alabama Supreme Court decision that I keep talking about, because what happened was after that decision came down, Donald Trump, then approaching candidacy for re-election, sort of sent out the message, I want to be the father of IVF, and he promised over the course of his campaign that he would guarantee free IVF to everyone in this country. He never specified exactly how, but this was a guarantee that you would have free IVF under a second presidency. The Washington Post recently published an excellent article profiling a public sector worker in Michigan. She worked for, I think, the Forest Service, who was undecided in 2024 and got into the voting booth and said, you know what, I need IVF and I really want it to be free, so I'm going to vote for Donald Trump. And then she was laid off within 2 weeks of Trump taking the presidency because she was probationary, and of course, they were all illegally fired. I mean, it's funny, it's also devastating, right? It's hard to square. The executive order was his attempt to follow through on this promise. His spokeswoman said after he issued this order, promises made, promises kept. But the order doesn't do anything. Anything. It certainly doesn't require insurers around the country to cover IVF. That would require an act of Congress, which would have to be budgeted, and it would make it more difficult to cut trillions of dollars in taxes for wealthy people if Congress were simultaneously trying to budget universal IVF care. So that certainly didn't happen. All the executive order says is, oh, insurers should think about this. They should think really hard about this. And then when they're done thinking, they should either do something or not do something. It's their choice, because we believe in free enterprise in this country. I just want to note where this leaves us. This leaves us in a place where most states that require IVF coverage through insurance are blue states, states that also allow a full spectrum of reproductive health care, including abortion. And the states that do not require IVF coverage are abortion ban states. States whose legislatures and governors and attorneys general go out on the stump and promise that they love babies and they love families. And their goal isn't to criminalize women. They just want to help American families build new generations and thrive, but they're not going to do anything like actually ensure that families can build new generations and thrive. They're just going to throw women in prison. That's their only tool. And while I'm on this subject, I just have to sort of close the circle here and note that it's 2025. We're at a 2025 symposium. We're coming up on the 3rd anniversary of Dobbs. We were promised by the anti-choice movement that once they got rid of Roe v. Wade, once they harpooned the white whale, that they would pivot to what they really deeply care about, which is protecting women and children, helping healthy women deliver healthy pregnancies, protecting infants and babies and children, making sure that they had access to food and medicine and that they could all thrive together. And right now, at this moment, the states with the highest levels of maternal and infant mortality are the exact same states that ban abortion.
And the exact same states, what else, Mark? They're the former Confederate states.
They are the traitors, generations forward, the great-great-great-grandchildren of the Confederate rebels, are the ones who are banning abortion, suppressing and subjugating predominantly women of color, and breaking the promise to actually protect families and children. So,
And white women get caught in that too. And maybe
Yes.
we'll get that to Q&A, because that is the point, that legal precedent
Yes.
is legal precedent. And that's the gap that's not really filled. And then that, of course, gets us to Buck v. Bell, eugenics, and all of that.
yes. I don't even remember what my question was now. I've been ranting for so long. Tell me it. I'll give you 30 seconds, and then we'll do Q&A.
Should we be skeptical? And
Should we? So yes, we should be skeptical as hell. I think we should be really, really angry, because I think that there were a lot of people who believed the anti-choice movement when they said this. I think there were a lot of good faith people, maybe undereducated, but good faith, who thought, yes, that's right, these two things go hand in hand. banning abortion, protecting women and children. You look at the signs at the protests, it said protect them both, right? And here we are now coming up on 3 years later, and it has only gotten dramatically worse for women and children. Health outcomes are radically worse now in places that have banned abortion. Women are coming to emergency rooms with failing pregnancies being told, go wait in your car until you are hemorrhaging because we can't treat you until then. And I'm not seeing the outrage, and I would like to see some more of that outrage, because as long as states like the former Confederacy can just keep sort of coasting, pretending that they care about protecting women and children while only using the hammer of abortion bans to punish people for pregnancy outcomes, that is the worst case scenario for where we could be now 3 years after Dobbs, and we need to turn it around, or else we're in for an even more dystopian future.
So I see there are other hands, but we have to finish. But the panelists will be here, and would you join me, please, in thanking them?